Having heard the argument of counsel, and in the light of the public interest this trial has enjoyed, I provide the following brief reasons for the order that I have concluded should be granted in regard to Mr. Zuma's application for an adjournment. These brief reasons are not exhaustive of all the arguments that were considered, and I reserve the right to amplify these reasons in the fullness of time, should the need arise, although the order granted is interlocutory in nature. Following my judgment of 26 October 2021, dismissing the plea in terms of section 106(1)(h), that is the special plea, read with section 106(4) of the Criminal Procedure Act 51 of 1977, Mr. Zuma filed an application for leave to appeal against the dismissal of the special plea, applying also for further evidence to be adduced on the appeal, applying for leave to appeal to the Supreme Court of Appeal on the grounds of section 317 of the Criminal Procedure Act, and stroke all for a special entry of an irregularity or illegality to be made on the record, and then finally applying for leave to appeal to the Supreme Court of Appeal on the grounds of section 319 of the Criminal Procedure Act 1977, and stroke all for the reservation of questions of law for consideration by the SCA. On 16 February 2022, I dismissed the application for leave to appeal and all the related applications, and directed that the criminal trial should proceed during the second and third terms of the 2022 calendar of this court, commencing at 10 o'clock on the 11th of April 2022, being the date also to which the trial was previously adjourned on the 26th of October 2021. On the 4th of March 2022, Mr. Zuma filed a petition against my aforesaid judgment with the Supreme Court of Appeal, seeking leave to appeal to that court. On the 18th of March 2022, Mr. Zuma filed an application in terms of section 168 of the Criminal Procedure Act for the postponement of the trial due to commence today, that is the 11th of April 2022. His application was based on the petition pending before the Supreme Court of Appeal that he wished to exhaust all rights available to him, and that this court should exercise its discretion to adjourn the matter either sine die or to a date to be fixed. On the 31st of March 2022, the two judges of the Supreme Court of Appeal dismissed the application for leave to appeal. On 7 April 2022, Mr. Zuma filed a notice of application in terms of section 17(2)(f) of the Superior Courts Act 10 of 2013, which I shall hereinafter refer to as the reconsideration application, with the registrar of this court. This reconsideration application was filed with the registrar of the Supreme Court of Appeal on the 8th of April 2022. Section 17(2)(f) of the Superior Courts Act provides, and I quote, "The decision of the majority of the judges considering an application referred to in paragraph B, or the decision of the court, as the case may be, to grant or refuse the application shall be final, provided that the President of the Supreme Court of Appeal may, in exceptional circumstances, whether of his or her own accord or an application filed within 1 month of the decision, refer the decision to the court for reconsideration and, if necessary, variation." Section 17(2)(f) of the Superior Courts Act applies to both criminal and civil matters. It is common cause that the application for the adjournment before me today is now in the main based on this reconsideration application in terms of section 17(2)(f) of the Superior Courts Act. Whether the special plea is appealable, or more correctly, whether the dismissal of the special plea is appealable prior to conviction, which I had found that it was not, and whether, if it is appealable prior to conviction, such appeal will be governed by the provisions of the Criminal Procedure Act or the provisions of the Superior Courts Act, which, regardless of the basis thereof, I had refused, are not the issues which now arise for consideration. I had previously decided those and am, in regard thereto, functus officio. The issue for consideration is the reconsideration application that has been filed with the President of the Supreme Court of Appeal and which awaits her decision as part of the further appeal process. Whatever the legal position might be as regards the appealability of the dismissal of the special plea prior to conviction, and if competent, specifically whether it is an appeal in respect of a matter regulated in terms of the Criminal Procedure Act or in terms of any other criminal procedural law as contemplated in the definition of appeal, or whether it is an appeal in terms of Chapter 5 of the Superior Courts Act, or whether there is some other statutory basis for entertaining such an appeal, a reconsideration application is patently an application in the appeal process expressly recognized in Section 17 of the Superior Courts Act, dealing with leave to appeal generally. It is therefore an application governed by the provisions of Chapter 5 of that Act. Accordingly, since the filing of the reconsideration application, the decision of the SCA dismissing the application for the various petitions made to it is, quote, a decision which is the subject of an application for leave to appeal or of an appeal, unquote. That is, to obtain leave to appeal in respect of the dismissal of the special plea on reconsideration as contemplated in Section 18(1) of the Superior Courts Act. The reconsideration application is part of an application for leave to appeal. Sections 18(1) and 2 of the Superior Courts Act provide, and I quote, 1, subject to subsections 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or of an appeal is suspended pending the decision of the application or appeal. Subsection 2 provides, and I quote, subject to Section 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal or of an appeal, is not suspended pending the decision of the application or appeal. The Supreme Court of Appeal's dismissal of the application for the petitions is not an interlocutory order, nor does it not have the effect of a final judgment, as contemplated in Section 18(2) of the Superior Courts Act. An application to reconsider an order of the Supreme Court of Appeal refusing a petition is an application for leave to appeal or of an appeal as contemplated in Section 18(1) of the Superior Courts Act. The operation and execution of the decision of the SCA dismissing the application containing the various petitions is accordingly suspended by operation of law. With due deference to the procedures and jurisdiction of the Supreme Court of Appeal, it means that the procedure is suspended and that the trial cannot proceed and should today be adjourned. That follows as a matter of law. It does not seem to me that this court has much of a discretion, if it has one at all, to deny those appeal rights statutorily ordained, unless perhaps in the clearest of cases where there is an abuse of rights. The appeal process should be allowed to run its course. Mr. Zuma has challenged many decisions adverse to him in the past, usually invoking the entire appeal process to the highest courts in this land, and in many instances has been unsuccessful, which resulted in inevitable and unfortunate delays. He is also on record through previous counsel representing him that he will continue to exercise all rights available to him. But the exercise of those rights, as much as they may be viewed with suspicion and distrust from certain quarters as resulting only in delays, which only favor him, do not per se amount to an abuse of those rights. A finding of mala fides would require more and clear proof by the state, which I cannot make on the allegations in the present papers alone. On the peculiar facts relating to this matter, a final decision from the Supreme Court of Appeal as to whether it might revisit its decisions inter alia in Ndluli and Porritt as clearly wrong, remains outstanding until a decision is taken whether to reconsider the decision on petition or not. The opportunity for reconsidering that outcome and other possible relevant considerations in the application for the various petitions by the SCA, although it will regrettably result in further delay, is statutorily ordained. To the extent that it will result in delay, it would be a delay which would not be unreasonable, but in our constitutional democracy, on the laws it presently stands, unfortunately unavoidable. When weighing all the relevant facts and circumstances alluded to by the parties, the conclusion I have reached is that the trial must be adjourned to allow the reconsideration application submitted to the President of the SCA pursuant to the proviso to Section 17(2)(f) of the Superior Courts Act to be disposed of. Criminal trials are not generally adjourned sine die. There is no compelling reason why the present trial should be adjourned sine die. It is well overdue. As much as the interests of justice demand that Mr. Zuma's reconsideration application should be allowed to be disposed of, there is also the interest of justice that demand that litigation must reach finality. The future progress of the trial must be closely managed by appropriate judicial oversight. As soon as the decision of the President of the Supreme Court of Appeal is made and those proceedings are disposed of, the trial should proceed, absent any other compelling reason. The trial was adjourned on the 26th of October 2021 to the second and third terms of the 2022 court calendar of this court, commencing on 11 April 2022. In view of the delay which will result from the adjournment, provision must be made for the continuation of the trial also into the fourth term of this court's calendar. The following order is therefore granted. A, the trial is adjourned to 17 May 2022 as a holding date, pending the decision of the President of the Supreme Court of Appeal in respect of Mr. Zuma's application in terms of Section 17(2)(f) of the Superior Courts Act 10 of 2023. That more correctly should read in terms of the proviso to the section. B, the adjournment is granted on the basis that if the application in terms of Section 17(2)(f) of the Superior Courts Act has been disposed of by 17 May 2022, the trial shall resume at 10 o'clock on the 31st of May 2022 and shall continue thereafter for the remainder of the second, third and fourth terms of the 2022 court calendar of this court. C, if the reconsideration application has not been disposed of by the holding date, then a further holding date and date for the continuation of the trial shall be determined on the holding date. And then I've added, more particularly for your client, Mr. Roo, D, on the basis that the accused undertake to appear on 31 May 2022 or any subsequent date fixed for the resumption of the trial, Mr. Zuma and the representative of Thales are excused from attendance on the holding date and any subsequent holding date that may be fixed by the court. And that is the order.
As please the court, no?
As the court pleases, my lord.
Court will rise.